સાહેબ સેલરી લેવાનો હતો સાહેબ, એમને કીધું કે તમે સિગ્નેચર કરીને મારા વતીથી આપો સાહેબ, તો મેં આપી સાહેબ. મારા વોટ્સએપમાં સાહેબ એ પછી બી ચેટિંગ ચાલુ છે સાહેબ કે મારો સેલરી મને આપો. હું હજી ટિલ ટુડે પણ સાહેબ મારો સેલરી જે 7-8 લાખ રૂપિયા બાકી છે હું આપું છું સાહેબ. મેં રેઝિગ્નેશન આપ્યું પણ સાહેબ સેલરી તો હું માંગીશ છે, મારું બાકી છે સાહેબ. એટલે હા એટલે સાહેબ એ ઇમ્પ્રેશનમાં જ કે સાહેબ મને પૈસા આપશે, એમણે કીધું થોડું વેઇટ કરો એટલે સાહેબ આ મેં કાર્યવાહી કરી સાહેબ. સાચી વસ્તુ છે પણ મારી રકમ સાહેબ બહુ નાની છે, જેના લીધે છે સાહેબ રકમ બહુ મોટી છે.
ના એમ્પ્લોય એટલે પણ સાહેબ
એવું તપાસ કરે કોપી
કોપી આપી દે છે.
અને બીજું સાહેબ એમના એકાઉન્ટની એટીને તપાસ કરવાનું સોમવારે તો 500
મારા એકાઉન્ટમાં છે એટલે બીજી કોઈ પૈસા નથી આવ્યા, મારા જે સેલરીના પૈસા છે
દર્શન મેના એકાઉન્ટમાં નતા પૈસા.
એટલે કોઈ ક્લાયન્ટના સાહેબ મારા ખાતામાં પૈસા નથી આવેલા
નથી આ દર્શન મેના ખાતામાં એક પૈસો નતો આવ્યો.
પણ એ હા નહીં કામ નથી સાહેબ ચાલુ રાખ્યું. મેં રેઝિગ્નેશન આપ્યા પછી એમના કહેવા મુજબ ખાલી અરજી સાહેબ કરી જે લોકલ પોલીસ સ્ટેશન જે કરવી હતી સાહેબ એ મેં અરજી. બાકી
પેલી જે આમણે સાહેબ એની એક્નોલેજમેન્ટ સાથેની કોપી આપો કઈ તારીખે કયા જગ્યા તો
આપી દીધું સર કચેરીમાં જઈને કોપી કરાવી એમને કરી દીધું.
ભાર્ગવ એમાં બી ભાર્ગવભાઈની સહી છે.
જે રીતે ભાર્ગવભાઈની સહી છે, હિનલબેનની પહેલી સહી છે, ભાર્ગવભાઈની બીજી સહી છે.
પણ બે પેપર
કોપી પોલીસ સ્ટેશનને ઉદ્દેશીને છે સાહેબ, આ કમિશનરને ઉદ્દેશીને છે અને સાહેબ એમાં કન્ટેન્શન સેમ છે સાહેબ. કન્ટેન્શન સાહેબ સેમ છે કે વિનય સચદેવાએ સાહેબ જે પૈસા લીધા છે
મારે તપાસ ક્યાં કરાવવાની એટલું મને સાહેબ ખબર પડે
સત્યચંદ્ર સાહેબ લોકલ પોલીસ સ્ટેશનમાં જ આવે.
આમાં એવું થયું છે સર, આ જે ફરિયાદની વાત છે ને એ ફરિયાદમાં એવું છે એ સર હું પૂછું હું પૂછું
હા બધા બધાના એકાઉન્ટ તપાસ કરે
આ કંપની
ઓફિસે બોલાવેલા અને ગોઠવણ કરી પોલીસને બોલાવી અટક કરાવી દીધી. ત્યારબાદ ટ્રાયલ કોર્ટમાં જામીન હતી. સમાધાન માટે ત્યાંથી જ અરેસ્ટ 100 નંબર ફોન કર્યો એટલે વર્ધીમાં લોકેશન 45 લાખની અમાઉન્ટ છે સાહેબ. ના સાહેબ એમણે કોઈ અરજી જ મૂવ નથી કરી. એટલે એમણે કન્ડિશન માંગી છે પણ સાહેબ સેપરેટ સેક્શન હવે તો એડ કરવામાં આવી. એમણે અરજી મૂવ કરી નથી, મને કોપી સર્વિસ થઈ નથી. તો સાહેબ કલકત્તામાં આમના સામે બીજી એક ફરિયાદ ચાલે, એમાં એમના વિરુદ્ધ વોરંટ છે, આ મૂળ ફરિયાદી વિરુદ્ધ, એટલે ડિસ્પ્યુટ છે. સાહેબ આવતા જ નથી ને, ત્યાં આવતા જ. હું તો સાહેબ હાજર થયો મેટરમાં, એ તો મેટરમાં સિંગલ ટાઈમ હાજર જ નથી થયા. મેં સાહેબ અંદર મેન્શન પણ કર્યો કેસ નંબર. ના, મેં પ્રાઇવેટ કમ્પ્લેન 156(3) પ્રમાણે અરજી કરી હતી, પ્રાઇવેટ કમ્પ્લેન ચીટિંગની. એટલે હજી હેલ્ડ નથી થઈ, ઇન્કવાયરીના સ્ટેજે ત્યાં ના ના, એટલે સાહેબ એમાં એમને સતત બોલાયા, કોર્ટમાંથી નોટિસ કાઢી, તેમ છતાં નથી આવ્યા. માલ બાબતનો તકરાર છે, વર્ષોથી ધંધો સાથે કરતા હતા. અમે સાહેબ માર્કેટિંગ એજન્સી છે. હા, એમના પાસેથી મેડિકલ ફાર્માનો માલ લેતા હોઈએ, એ બાબતની જ તકરાર છે સાહેબ. અમે સાહેબ થર્ડ પાર્ટી ટ્રેડર તરીકે એજન્સી હોય બીજાને વેચાઈ. જી સાહેબ, અમે તૈયાર જ છીએ સાહેબ, બેસીને જે પણ નિરાકરણ આવતું હોય, એટલે પછી બેસીને જે પણ નિરાકરણ આવતું હોય અમે તૈયાર જ છીએ. અમે કોઈ દિન
ફાઇલ કરવા માટે ડેટ રાખવાની ઓબ્જેક્શન ફાઇલ કરવાનું આવતીકાલે રાખવાની છે.
એવું જ સાહેબ મીડિયેશનમાં પણ નીચે ટ્રાયલ કોર્ટ રાખશે, અમે એગ્રી જ છીએ. અમારે તો સાહેબ એક એગ્રીમેન્ટ છે બે વચ્ચે, જે હમણાં ફરિયાદમાં છુપાયું. તો સાહેબ એમને એગ્રી નહીં હોય તો હું ટ્રાયલ મૂવ કરવા રેડી છું. પ્લી તો થઈ ગઈ છે અમારી સામે સાહેબ.
આવતીકાલે રાખવાની ડેટ છે સર. તો હજી અમને કોપી બી
નોટિસ ભેગી જાય છે બે.
આવતીકાલે રાખવાની છે.
તોડ
આરોપીઓ જે છે ગુજરાત રાજ્યના ગાંધીનગર જિલ્લાના કલેક્ટર સાહેબ, અડાલજ, ડભોડા યુનિવર્સિટી પોલીસ સ્ટેશન, અમદાવાદ શહેર વસ્ત્રાપુર પોલીસ સ્ટેશન અને પાટણ અને સુરેન્દ્રનગર જે આ જિલ્લાઓ છે એની અંદર નિરંતર છેલ્લા 10 વર્ષની અંદર ગુનાહિત પ્રવૃત્તિઓ કરતા આવેલા છે. જે આ સિન્ડિકેટ છે 4 વ્યક્તિઓની, એની સામે છેલ્લા 10 વર્ષની અંદર ખૂનની કોશિશ, બળજબરીથી ઘડાવી લેવાના, આમજગ, મહાવેરના, પ્રાણઘાતક હત્યા સાથે ઉઘડ બનાવટી દસ્તાવેજો ઉભા કરવા, રાયોથી, ધાકધમકી અને નાણાં ઉઘરાવા સંબંધના ઓફેન્સીસ રજીસ્ટર થયેલા છે. ઇન્વેસ્ટિગેશન દરમિયાન આરોપીઓ વિરુદ્ધ ગુનામાં દાખલ થયેલી ફરિયાદમાં આરોપીઓ વિરુદ્ધ જેને ફરિયાદ દાખલ કરેલી હોય એ બધા સાહેબો, પછી ઓફિસર્સ જેમને ચાર્જશીટ ફાઇલ કરેલી હોય એ લોકોના નિવેદન લેવામાં આવેલા છે. ઇન્કમ ટેક્સ વિભાગની અંદરથી જરૂરી આરોપીઓ વિરુદ્ધ માહિતીઓ મંગાવવામાં આવી છે, જેની અંદર કરોડો રૂપિયા નથી. એની અંદર સાહેબ ટોટલ 55 વિટનેસીસને સાઇટ કરેલા છે ચાર્જશીટ. અમુક સાહેબ પંચાયતની બધા છે એટલે સાહેબ સાહેબ sufficient material એ અપાઈ ગયું છે એ અપાઈ ગયું નોન નોન સાહેબ હું અમદાવાદ સ્ટોપ
The charge against me is under section 7 of PC Act, read with 120B. Now, with all due respect, it is not specified as to which of the subclauses of section 7 is being invoked against me. It has 3 parts, but I don't know which one are they trying to invoke. So this is my first argument, that the charge sheet itself is vague. They have just, what they have done is, somehow all the facts have been just put together and thrown over this court that keep on deciding what is to be done. And when I go take your honor through everything, then it will be clear that how the investigation in this particular case has been done. The complaint in this case was filed by Madhurbhai Sakaria on 16/2/21, sir. There's a written complaint. The written complaint, the translation I have put, but page number 95 of my compilation. At page 97, sir, para 2, at page 97, this is the crux of the whole complaint. He says that Rajesh told that all the opinion against me were negative. However, he assured me that despite these adverse opinions, he would approve my self-defense weapon license if I complied with his demands. I agreed to follow his instructions. K. Rajesh then stated that he had purchased new clothes in Surat and needed to settle an outstanding amount of 1 lakh. He provided me with a bank account number in Surat for that purpose. Now kindly see, he is here in the complaint, he's saying that when for the first time he informed me about the negative opinion, at that very time, he gave me the account number of this shopkeeper. This is very, very important because all his other statements, in fact, the conclusion of the statement is entirely different. The charge sheet. The conclusion from this complaint is entirely on a tangent. Then he says that in addition, K. Rajesh demanded, page number 98, sir, second paragraph, demanded and received cash payments from me in his chamber on multiple occasions, 50,000 twice, 1 lakh thrice, amounting to 4 lakhs. So he says in total he paid 4 lakh 98,000 by depositing in the account of in the account of Rafiq, the accused number 2. And the other amount was paid in 5 installments, that is the 4 lakh rupees. So here the case of in the complaint, the case of the complainant is that 4,98,000 was paid to me, and 98,000 was immediately paid on the very date when the quid pro quo, alleged quid pro quo happened. And 4 lakhs were paid later on in 5 installments on multiple occasions. Then, sir, other date which is very important is 10th June 2019, sorry, which is the date of grant of license. 10th June 2019 is the grant of arm license. That is the very important date, because he says that I told him negative है, मैं दे दूंगा और तू मेरे अकाउंट में पैसा जमा करा दे. 10 जून को लाइसेंस इशू हो जाता है. The money which is deposited in Rafiq's account, the alleged money of 98,000, is in September. So, while the complaint talks about I already having purchased the clothes before 10th of June, so his case is that I asked him to pay before 10th of June, while he deposited after 3 months in September 2019. And sir, let me clarify that I am not showing all this to this court to show any contradictions, because that would be in the domain of evidence. I am only trying to say that before this honorable court, there are 4 different cases which have been placed by the prosecution. 4 different cases. And those 4 different cases, this court is called upon to find out which one this court wants to rely upon. Because to frame charge against me, this honorable court will have to give particular facts that this is the charge against you. Now, if there are 4 different sets of facts which are there in the charge sheet itself, no more, no further evidence, nothing else. So this court, how it is possible for this honorable court to determine as to which set of the facts this court must utilize for the purpose of framing of charge. That is what is my argument. And I am going to seek the help of a Supreme Court judgment where the court says that if there are 2 views possible, then, and if one view helps me, then the view which helps me would be would sustain, and I will have to be discharged. So that is the only prime purpose. I will not take too much of time. I'll just quickly take your honor through all that. Then, sir, this very person gives a statement. The complainant gives a statement to ACB inspector, Mr. Jhala. This again is a document on record. It is at page number 110. ACB records his statement. ACB Gujarat. Only within 1 week of filing of his complaint, that is on 23rd of February 2021, again he says, now he says his story changes. Page 111, para 2 and para 3 is para 2 again he says that he told me negative opinion is there. And I agreed to do whatever he says. And then in the very second paragraph, on 10/6/2019, 2 or 3 days after receiving the official order approving my weapon license from the Surendranagar District Collector's Office, I visited the collector's office for community work. I met Mr. K. Rajesh in his office. where he stated, I have purchased new clothes. So there in the complaint, he says that at the time I informed him that negative reports are there and I will give you the license. Here he says that no, it is after I received the license. After that, 2-3 days, I went to the collector's office. Now he said that I have purchased the clothes. Here is a totally different story altogether. And he then wrote a Surat bank account number and so and so. And I deposited the amount. Again, I am saying, sir, that suppose it was 2-3 days, let's say 13th of June 2019. The money was deposited on 6th and 7th of September. How is it possible? What is this case? And there is another story to it. Then, sir, subsequently, next para, subsequently, whenever I visited collector's office for community work, K. Rajesh demanded cash from me on multiple occasions. Consequently, I handed him 1 lakh rupees on 3 separate occasions, totaling to 3 lakhs in cash on different dates, adding the amount. Now he says 3,98,000. Within 1 week, the amount gets reduced from 4,98,000 to 3,98,000. And 5 installments get reduced to 3 installments. Then, answer, very important fact is that in the complaint, while the demand is prior to the license, here what he tells Jhala is that demand was after the license was granted. So I do not know whether it will even fall in within section 7 or not, if it is afterwards. Now, sir, then he says, sir, then there is a report by, then there is a 161 statement which he gives to the present IU. Page 135, sir. Page 135 of my compilation, sir. 135. Para 2 of, very, very important, sir. Para 2 of the statement itself. Pardon, sir? This is statement of Madhurbai Sakaria, the complainant, given to CBI. The IO of this particular case. This is the statement now he gives to the CBI. I belong to Koli, para 2, sir. I belong to Koli Samaj. I am so and so Pramukh. On being asked about Soma Ganda Patel, ex-MP, I state that I know him since 2001. He was contesting the election of MLA from Tehsil, so and so. He is our leader, as he also belongs to Koli Samaj. He is residing at so and so. I was with him in college. Sir, the other complaint, other charge sheet which is before Your Honor, that there the complainant is Soma Ganda Patel. And he says, I was with Patel in college near Kotharia and we discussed that K. Rajesh is being making harassment to people of my constituency by taking bribe. It was decided that the complaint should be filed on behalf of local public from Surendra Nagar. Thereafter, complaints have been sent to the PMO in respect of the corruption and abuse of official power. So he admits that all this is motivated. It has been planned. 120B is there. This is the 120B. That is what they both have hatched the conspiracy to frame me. He is admitting that he is my college friend and I have to frame him. This is what he is saying. And if Your Honor will see a main complaint which he has filed in writing, it is written by a lawyer where this man gives sections. Under this section, he has committed the offense. Under this section, he has committed the offense. It is a completely legally drafted complaint. And just see along with this, that both of them join their heads and conspire to frame me. Then, sir, what he say, what is done by the prosecution, because this statement is not signed by the accused. Now, we will take it is his statement. The statement of the complainant under 161, sir. Accused, no, it is complainant's statement. Page number 136, sir. Again, he says that Rajesh called me to his office and he told me in para number 2 that then he says, today I do not remember in para 3, today I do not remember a date on which I visited the office of K. Rajesh, was holding my file in his hand and informed me that he had received negative reports from various authorities on this. I asked him how, now what should I do? If you informed me earlier, I will try to positive report. But now what can I do after receiving negative report? Then K. Rajesh told me that I have to pay rupees 5 lakhs of bribe. I expressed my unwillingness to give bribe of 5 lakhs, which is a big amount for me. After that, the matter was ultimately settled for 4 lakhs. So this is yet another story. Earlier he says 4,98,000. Then he says 3,98,000. Then here he says there was a negotiation, which is nowhere in the complaint. And the amount was settled from 5 to 4. Accordingly, after 2 days, an amount of rupees 3 lakh was paid in cash. No installments now. So he says, I paid 3 lakhs in cash in one go. Five installments in complaint at different dates, much later, 3 installments before Jhala. And here he says, I do not remember the date. However, it was in one go the 3 lakh was paid. And very interestingly, the balance part where was paid by cash to Rajesh in person and asked me to arrange another 1 lakh. On being asked about the denomination of currency, I do not remember. Once I handed over the money, K. Rajesh signed an approval and shown to me and stated the approval letter will be given. So, in both those stories, the money was paid after, the cash was paid after the license was received. Here he says, once he paid me 3 lakhs, then I granted the license. So here the story completely goes on its head. Then, sir, Page number 137, sir. After lapse of 2-3 months, I went to the office of collector in connection with the other matter and met K. Rajesh. On meeting, K. Rajesh told me that I have to deposit 1 lakh. So now, sir, kindly see what has been done during the investigation. It was realized that the case has turned on its head because he has already made foolish. His story has been exposed before in the written complaint and before Jala. So in order to justify, 2 new facts were put. One was that it was negotiated so that they could justify the difference between 498 and 398. So that has been inserted now. The other thing which has been inserted is the difference between June and September. So they insert another story that after 2-3 months, while in both the other earlier cases, he says that at that very time he told me I have already purchased the clothes. Here, in order to clarify those, he now makes out yet another story and says, after 3 months I went, so he told me, so then I deposited the money. I ask myself, which one of these stories has to become the basis of framing charge against me? Pardon? Yes. Yeah. It's okay. It's okay. I don't want to waste the time. And sir, one very important thing happens here, that he is asked by the IO about the source of money. Cash kahan se aaya tere paas? Kindly see page number 142. Top question. You had handed over 3 lakh cash to K. Rajesh. Please state as to what is the source of 3 lakh rupees. Do you have any evidence that you had 3 lakh of rupees in your hand during the relevant point of time? I state that I am a businessman. I always keep cash at my home for meeting out daily and emergent expenses. I don't maintain such records of keeping cash in my home. I state that generally I receive payments from parties through check, but sometimes I receive payment in cash also from the local people. And the IO is satisfied, sir. IO doesn't ask any question thereafter. No documents are sought. No, not his balance sheets is sought. He's not even asked whether you pay income tax or not. So my respectful submission is that it is a case of no evidence. Otherwise, there will be no need for traps. Why would the traps be required? One person will come, he will say, I paid cash. And all the government officers will face trials for years together. If this is the way charge can be framed. The other thing he says, I deposited 98,000 rupees in some shopkeeper from whom I buy the clothes. It is very easy. Most of the people, even all of us, buy clothes from particular shops. Just because he has my number, just because I have his number in my telephone. That will become the proof of payment of illegal gratification. And that is how the bribery case can be made out. Very easy. Anybody can be framed like this. And where he says that I sat down with Somaganda Patel. He is my classmate from college. And we hatched the conspiracy. And this is the conspiracy which he hatches. My job before this honorable court is to address the conscience of this court. All other technicalities of law are, according to me, are secondary. If any reasonable man, any common man, any judge under these circumstances can even come to the conclusion that there is a suspicion that this man has done something wrong. Yes, the charge must be framed. But with all humility at my command, I submit that the facts of this case are such, the circumstances are such, that it is absolutely apparent that the case which has been fabricated against me. There is absolutely no truth which is apparent from the facts of this case. And then, sir, the government holds a preliminary inquiry by none other. I'm told, I did not know this man P.K. Taneja, but I'm told he's one of the most reputed, he's honored, respected for his honesty in this state. I was not aware about it. Be that as it may, he is a senior officer. The government appoints him to inquire. The record of his inquiry was with the prosecution, which is apparent from the fact that when I filed an application under 91 for presentation of Taneja's report, they did not say that we don't have. They did not say that you will have to summon it from the government. That means the prosecution had it. The prosecution, apart from the fact that how the case is made out against me, is also answerable to this honorable court why this document was held back. Just to frame me. What was required was that once Taneja's report, which says, I will take your honor through that, which says that there is no evidence against him, it was incumbent upon the IO to explain to this honorable court in all fairness as to why he disagrees with Taneja. Forget about all the technicalities of law. The fairness of investigation demands that once this report, along with all the records, because how I could convince this honorable court, because one questionnaire, accidentally they produced, they submitted, which Taneja had sent to you, to Rafiq. That questionnaire formed part of this record. That is how I could convince this honorable court that, sir, they have the record, they are not giving it. And this honorable court was kind enough to summon that report. And I will show that Taneja says that there is no evidence of payment of any cash or quid pro quo or of bribery. I'll straight away take your honor to Taneja's report. Page number 170 of my compilation. The very first line of Taneja's report is, by letter dated 16/2/2021. It is the same complaint which has triggered the FIR in this case. So, the set of facts investigated by Taneja, by Jhala, the ACB, and by the CBI in this particular charge sheet, they emanate from the same set of facts or same set of allegations. Pardon? Yes. Here also it says 4,98,000. Yeah. Kindly see page number 172 now, sir. Para 14. A statement is recorded of Madhurbai Sakaria by Taneja also in para 14. And after recording his statement, he takes up the case one by one. Para allegation number 1 at page number 176. Sir. Thus, on the basis of records, statements made available during the present preliminary inquiry, evaluation of evidence issue based and conclusions derived therefrom are stated here under. Issue number 1, allegation, since applicant Shri Madhurbai Sakaria was a social leader in so and so, if you make an application and so, then sir, the conclusion is at 177, just before issue number 1. Therefore, it becomes clear that Collector K. Rajesh had not himself advised the applicant to apply for weapon license, and accordingly, allegation issue number 1 is not supported. The allegation of the complainant is that I advised him to issue for the license. Then, sir, the allegation number 2, that he said that the report is negative, I shall do as you say, is at page number 177. And then the conclusion is at 184. Actually, yeah, 184 bottom, sir, just before issue number 3, sir. Thus, the allegation of issue number 2 of applicant that Collector K. Rajesh had purchased clothes from Surat and had asked to pay bill of rupees 1 lakh and had himself given bank account number does not receive support. 184, sir. Then, sir, next allegation at 184 itself, issue number 3. That K. Rajesh had taken from applicant on different days cash amount of rupees so and so, so and so, so and so. Then after discussing the evidence, at the bottom of this page, 184, no direct evidence regarding the same could also be produced by the applicant during inquiry. Therefore, issue number 3 of the allegations does not receive support. Yeah. Then, sir, 185 is the next allegation. That by giving 4 lakhs in cash as per the saying of K. Rajesh and by depositing of 98,000 in cash, the applicant's weapon license application, in which opinion of all officers were negative, was approved by him on so and so. Now the conclusion is at 187, sir. Last paragraph of 187. As stated in the above case issue, there is no support regarding the payment of 4 lakhs in cash, whereas regarding depositing 98,000 in cash in the bank account stated so and so, except representation of applicant Madhubhai Sakaria and witness statements, this matter is not supported in a statement of accused K. Rajesh as well as other witnesses. As per the statements of applicant, evidence regarding the bank account number so and so, which K. Rajesh himself had written and given to him, could not be produced by the applicant in the personal statement. Under these circumstances, this issue of allegation is without evidence and does not receive support. Then, sir, issue number 5 at 188. That this is regarding what he says. This is also very important, sir. What he says in his complaint is that he is in the business of mining, and while K. Rajesh was on leave, accused number 1 was on leave, one of the officers who works under him wanted to impose certain fine on Madhubhai Sakaria, which he actually did. Almost 24 lakh rupees worth of fine was imposed on him. He says that officer asked for rupees 5 lakhs, which I did not give. He also said that something will go to Rajesh. However, that is not the charge here. The charge here, the story which has been made out is that his weapon license was cancelled under the directions of K. Rajesh. That is what is the charge. That K. Rajesh instructed the officer in charge at that particular moment. Although he was on leave, he instructed him to cancel the license of Madhubhai Sakaria, the arms license, which was granted by me 13 months ago. This is what is his allegation. Although there is no quid pro quo in this, there is no section 7 in it. However, just to frame the story, just to give it the color, and because the complaint has been filed after 1.5 years, the license was granted on 10th of June 2019. The complaint has been filed on 16th February 2021. So it has been filed after 1.5 years. So how to justify all this? But while trying to justify all this, they have committed one more thing, that it becomes actually a counterblast. Once some officer under him imposes a fine on you, imposes a fine on the complainant, cancels his license, Then he remembers that he had paid the bribe. And after 1.5 years, he files this complaint in consultation with Soma Anda Patel, in consultation with a lawyer. So kindly see what kind of bribery allegation it is. Pardon? No, it's not required. Then, sir, if I'll just straight away come to the conclusion of Taneja's report. It is at page 199, sir. (199). In the present fact-finding inquiry regarding the complaint representation made by applicant Madhurbai Sakaria, there is no evidence to substantiate that K. Rajesh, then collector Surinder Nagar, had directly or indirectly obtained any kind of financial benefit in cash or in any other form, or committed any financial embezzlement, irregularity in relation to the grant of weapon license. However, though collector K. Rajesh possessed authority, his decision regarding grant and cancellation of weapon licenses cannot be said to be in consonance with the Arms Act rules as well as relevant instructions of the Home Department, and therefore he appears to be responsible for general administrative lapse of the nature of procedural lapses. What's the date of Taneja's report? Sir, just to give the date of Taneja's report, it is at page 169, sir. It is unfortunately in the translation. That report has not come. So the Gujarati version is at it ends at 169. The report date is 15/12/2021. So the whole investigation, everything takes place after Taneja. And this report is very conveniently kept in the dock. While the officer gives a conclusive finding, then, sir, but I'll come to later. The department issues a departmental charge sheet to me in this very manner. The charge sheet starts at 217. The translated copy is at 227, sir. The charge sheet is dated 25/7/25, sir. The very top of 227, page number 227. The date is given 25th July 25. Now there's the charge number 1. Charge number 1 is, despite adverse or negative opinion received from all concerned authorities regarding the arms license, application of Shri Madhurbai Sakaria during the hearing so and so, noted on the file, he is a leader of Koli community and so on. The decision has been made for such reasons. Furthermore, taking such a decision in this matter is a transactional act which is inappropriate. So there is a, while they deal with his license, that my disciplinary authority, which is the governor of the state, acting on behalf of the President of India, he deals with this issue, but finds no allegations of bribery. He only says that it is a case of procedural lapse. But where is the from his angle? Yeah. But sir, it means that so far as bribery allegations are concerned, I have been exonerated. Procedural aspects, yes, I have to answer. I will answer. But the disciplinary authority also, just like Taneja, finds no criminality in my act. And page number 230, it has all been explained very well. They deal with 98,000, they deal with everything else. The disciplinary authority deals with it. Kindly see page number 230. Reasons for not accepting the explanation. Under the provisions of Arms Act and corresponding rules, the authority to grant or reject an arms license vests exclusively with the district magistrate. Therefore, K. Rajesh, as the then collector, was empowered to approve so and so, so and so. However, the note recorded by him, his work in the matter of Thangad is to be taken, raises suspicion. It is established from the evidence on record that the applicant deposited a sum of rupees 98,000 in Vadhavan branch of the Bank of Baroda. Against this amount, garments were purchased from a cloth merchant in Surat, which was, that is accused number 2, which were subsequently distributed to the office staff in the chamber of the collector, Shri K. Rajesh, in his presence. Therefore, it can be reasonably presumed that the entire program was organized with the inspiration of the charged officer K. Rajesh. These facts become clear from the evidence on record. The timing and the manner of these events portrays a picture that while the applicant's arms license application was still pending with the collector, such inducements may have created a reasonable expectation in the mind of the applicant that the favorable action would be taken with regard to the application. Consequently, it appears that the applicant, acting under such belief, deposited the said amount, following which the garments were procured and a distribution of the program was conducted within the office premises. Given this sequence of events, it is reasonable to conclude that the organization of the program was not incidental, but was in fact closely related to the license approval process. From the applicant's perspective, not my perspective, this type of act can only be considered as an exchangeable oblique transactional act. The officer serving on the prestigious post of collector in the district is considered the highest representative of the state government, and therefore, due to the above acts, carried out by K. Rajesh as the then collector, the prestige of the government itself is tarnished among the public. Therefore, it can be said that by committing such acts and exhibiting behavior unbecoming of IAS, he has violated 3.1. Now, I will take your honor to what is 3.1. Kindly see page number 339 of my compilation, which are the All India Service Conduct Rules. At page number 340 are the conduct is the relevant 3.1. Every member of service shall at all times maintain absolute integrity and devotion to duty and shall do nothing which is unbecoming of a member of the service. While the bribery would fall, and they are not alleging anything to do with my integrity in the charge sheet, because the integrity is dealt with in 3.1a. If your honor will kindly see, every member of the service shall maintain high ethical standards, integrity and honesty. So they are alleging, which I will answer. So the only thing they are saying, it was unbecoming of you. That means you violated some rule. However, my integrity is not in question, because integrity is dealt with in 3.1a. Integrity is dealt with in 3.1a. The bribery is dealt with, the benefits to himself are dealt with in 3.2b. And 3.2b, 6 and 7. So there is no allegation by the government upon me of bribery at all. Even in the charge sheet, they find nothing against me. And let me explain that even that charge which they have maintained against me suffers with apparent falsity, apparent mistake. Because what they are saying is that the money was deposited in Vadhavan branch when the application was pending. Application was not pending. Application was sanctioned on 10th of June 2021, not 2019. While the money was deposited in Vadhavan branch after 3 months. That we will, pardon? Absolutely. 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 However, the law says that if there is no evidence, even for departmental proceedings, where a charge can be proved on preponderance of probability, so that the evidence required for criminal prosecution would be of a very higher degree. Yeah. So if the departmental proceeding does not find any evidence of bribery, even for issuance of the charge sheet to me, a departmental charge sheet, where they needed much lesser degree of proof, it is obvious, and there is enough Supreme Court, and so there are enough Supreme Court judgments on that. that suppose, sir, it was a case like this. Suppose the charge sheet had been issued to me in 2021 itself, the departmental charge. And suppose they had charged me with bribery also. And later on, they found the disciplinary authority after the inquiry would have found no evidence against me on the basis of preponderance of probabilities. I would be entitled to move an application before this honorable court for my discharge on that very basis. The Supreme Court says that if a person has been discharged in a departmental inquiry, then in that case, on the same set of facts, the prosecution cannot go on. If it is on merits. If it is on technicalities, no. The case can go on. But if it is on merits, here, when I read before this honorable court, Taneja together with the charge sheet, departmental charge sheet, yes. Yes. Yes, that is the law. Yes. It cannot be ipso facto. I'm coming to those cases. I'm coming to those cases. Yeah. Sir, page number 248 of my compilations. Yes. Normally lawyers are entitled for 10-15 more minutes when they say 30.
Indian standard
No,
time.
sir, that is the leniency the courts give to us. Yes. 248, sir. I will try to cover most of the things in my written submissions. However, just give me 5-10 more minutes. 248. Page number 248, sir. This is Supreme Court in a 3-judge bench of Supreme Court. Show me from where the judgment is starting. 241, the judgment is starting, sir. And the relevant portion yeah. Para 7 and para 8, sir. 245. The case there was that CBC report was negative, sir. So this was a reading of the report shows that at the highest the appellant may be negligent without any criminal culpability. In fact, the positive finding of the CBC that the appellant appears to be a victim of so and so plot of some importance. A number of judgments have held that the standard of proof in a departmental proceeding being on preponderance of probability is somewhat lower than the standard of proof in a criminal proceedings where the case has to be proved beyond reasonable doubt. In PS Rajya versus State of Bihar, the question before the court was posed as follows. The short question that arises for our consideration in this appeal is whether the respondent is justified in pursuing the prosecution against the appellant under section so and so, read with so and so, notwithstanding the fact that an identical charge, on an identical charge, the appellant was exonerated in the departmental proceedings in the light of a report submitted by the CVC. This court then went on to say that at the outset, we point out that the learned counsel for the respondent could not but accept the position that the standard of proof required to establish the guilt in a criminal case is far higher than the standard of proof required to establish the guilt in departmental proceedings. He also accepted that in the present case, the charge in the departmental proceedings and in the criminal proceedings is one and the same. He did not dispute the findings rendered in the departmental proceedings and ultimate result of it. Then, sir, page number, para number 14. Page 248. Para 14. Yeah. Yeah, page number 248, para 14. Just before para 14, one more paragraph. In our opinion, therefore, the yardstick would be to judge as to whether the allegations in the adjudication proceedings as well as the proceedings for prosecution is identical, and the exoneration of a person concerned in adjudication proceedings is on merits. In case it is found to be on merits, that there is no contravention of the provisions of the Act in the adjudication proceedings, the trial of the person concerned shall be an abuse of power of the court. From our point of view, para number 38, 7, 8 is important. And if the High Court had bothered to apply that parameter, then on reading of CVC report on the same facts, the appellant should have been exonerated. Applying the aforesaid judgments to the facts, it is clear that the view of the CVC order, so the chances of conviction in a criminal trial involving the same facts appear to be bleak. We therefore set aside the judgment of the High Court and discharge the applicant. So it was a case of discharge only. Just pardon. Okay. Have you given? Okay. The page 472 of my compilation. There are many other judgments which I have given, but I'll just take through one or two judgments only. Page, it starts with 470. Judgment. Then, sir, 472. Para 8, middle of the paragraph, about 10 lines. It then does not appeal to reason to say that while the officer had committed no misconduct on the basis of one set of allegations, the officer had prima facie committed criminal offense on the basis of the same set of allegations. It is pertinent to mention here that the criminal complaint filed against the applicant by informant so and so does not contain any more allegations than what formed the basis of the charge number 1 leveled against the appellant in the department inquiry proceedings held against him, in which the applicant has been exonerated. If it then follows that the criminal investigation being carried out against the applicant in its present form cannot continue. So here it is a case of investigation. They said even investigation cannot continue. It is a Bombay High Court judgment. Then, sir, 369. Yes. Page number 361 first, the judgment starts at 361. And the relevant portion is at 369. Para 28. Has you not got it? 369. Para 28, before parting with this case, this court would like to emphasize that where there is a pending civil dispute between the parties, the police and the criminal court must be circumspect in filing a charge sheet and framing charges respectively. In a society governed by rule of law, the decision to file a charge sheet should be based on investigating officers' determination of whether the evidence collected provides a reasonable prospect of conviction. The police at the stage of filing of the charge sheet and criminal court at that stage of framing of charge must act as initial filters, ensuring that only cases with a strong suspicion should proceed to the formal trial stage to maintain the efficacy and integrity of the judicial system. The tendency of filing charge sheets in matters where no strong suspicion is made out clogs the judicial system. It forces judges, court staff, and prosecutions to spend time on trials that are likely to result in an acquittal. This diverts limited judicial resources from handling stronger, more serious cases, contributing to massive case blockage. Undoubtedly, there can be no analysis at the charge framing stage as to whether the case would end in conviction or acquittal. But the fundamental principle is that the state should not prosecute citizens without a reasonable prospect of conviction, as it compromises the right of fair process. In the present case, the police and the trial court should have been cognizant that there was a pending civil dispute, so and so. Now, sir, why I am talking about the civil dispute here? Because it is clearly a counterblast. Because a fine was imposed against him, there is no explanation anywhere in the charge sheet to that aspect. That when it is absolutely clear that this man, because he was aggrieved of that fine, that is why after 1.5 years he took it upon himself. One more judgment and sir, I am done. 371, sir. Page number 371. It is the judgment of Yogesh. Page number 377 is the relevant portion, just before para 17. 377. Has you now got 377? Just before para 17. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him gives rise to suspicion only as distinguished from grave suspicion, he will be fully within his right to discharge the accused. At this stage, he is not to see whether the trial will end in conviction or not. The broad test is to be applied is whether the material on record, if unrebutted, makes a conviction reasonably possible. So my respectful submission is that no conviction in this case is reasonably possible. So because state itself has 4 views here. State has 4 views, sir. I am highly obliged for the indulgence.